In this unit, we tackle two unrelated issues that have been controversial in recent constitutional jurisprudence: same-sex marriage and assisted suicide. As we've seen in our study of substantive due process so far, the intimate relationships of sexuality, child-rearing, and marriage have been at the heart of the court's understanding of privacy. The abortion cases conceive of the abortion decision as a private matter of conscience involving the woman alone or perhaps the woman and her doctor. Cases since the 1960s involving marriage and child-rearing, however, have tended to draw both on substantive due process and on the Equal Protection Clause of the 14th Amendment. This includes Loving v. Virginia, the 1967 case that struck down a Virginia ban on interracial marriage. It's hard to imagine that as late as 1967 any state law would prohibit interracial marriage, but such anti-miscegenation laws were common throughout the United States from colonial times onward. Many free states repealed their anti-miscegenation laws prior to or shortly after the Civil War, and other states followed suit after the constitutionality of such laws increasingly came into question after World War II. But when Loving was decided, 16 states, including Virginia, still had anti-miscegenation laws on their books. In his opinion for a unanimous court in Loving, Justice Warren stated that the freedom to marry has long been recognized as one of the vital personal rights essential to the orderly pursuit of happiness by free men. Marriage is one of the basic civil rights of man, fundamental to our very existence and survival. Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state. The court applied a similar rationale in a number of subsequent cases challenging statutes that restricted the right to marry or narrowly defined the concept of a family, though not every such challenge was successful. Prior to Bowers v. Hardwick in 1986, none of these marriage and family due process and equal protection cases concerned same-sex relationships. In Bowers, by a 5-4 majority, the court upheld a Georgia statute prohibiting sodomy as applied to same-sex conduct. Such sodomy laws historically were common in the United States, but many states had begun to relax these laws starting in the 1960s, and even those states with sodomy laws on the books often did not enforce them, at least against heterosexual couples. At the same time, in many places, LGBTQ people were subject to harassment by law enforcement, and the sodomy laws were often selectively enforced against gay people. In his majority opinion, Justice White stated that the earlier substantive due process cases were interpreted as construing due process to confer a fundamental individual right to decide whether or not to bear a child, but that no connection between family, marriage, or procreation on the one hand and homosexual activity on the other has been demonstrated. Justice White, as well as Justice Berger in a separate concurrence, also noted long-standing legal and moral prescriptions against sodomy. The dissenters, led by Justice Blackmun, said the case was about the right to be let alone in a sensitive key relationship of human existence. Both before and after Bowers, there was activism in some states to soften or repeal sodomy laws and laws against same-sex conduct. There was also activism around recognizing sexual orientation as a protected class under state civil rights statutes. We'll come back to some of these concepts in more detail when we study the Equal Protection Clause. For now, note that constitutional protections generally apply between an individual and the government, not against private conduct between individuals. If we want the law to prohibit some kind of private discriminatory conduct, say a whites-only policy at private hotels and restaurants otherwise generally open to the public, this can usually be accomplished only by legislation. The Civil Rights Act of 1964 was a landmark piece of federal civil rights legislation that prohibited various kinds of discrimination based on race, color, religion, sex, and national origin. There was no such federal legislation specifying sexual orientation as a protected class. There still is no such federal civil rights legislation specifically covering LGBTQ people, although a 2012 Department of Housing and Urban Development regulation prohibits discrimination against LGBTQ people in federally assisted housing programs. Starting in the early 1970s and accelerating in the 1980s and 1990s, some states and municipalities began enacting employment discrimination and other civil rights laws covering LGBTQ people. Some social conservatives argued that LGBTQ identity was not an inherent immutable characteristic like race or gender and therefore should not be a protected class. Of course, even these arguments usually oversimplified the concepts of race and gender, both biologically and in terms of personal identity. Many of these social conservatives perceived, correctly, that opening these civil rights protections in housing, employment, and the like would lead to arguments about marriage equality. Other social conservatives were worried that civil rights protections would not include what they considered adequate exceptions for religious institutions with traditional views about sexuality and marriage. In the early 1990s, Colorado became ground zero for these debates. This was in no small part because Colorado Springs was home to some very influential and very conservative interconnected religious organizations that were able to mobilize a politically active base. In 1992, Colorado voters approved an amendment, Amendment 2, to their state constitution that stated as follows: "Neither the state of Colorado, through any of its branches or departments, nor any of its agencies, political subdivisions, municipalities, or school districts shall enact, adopt, or enforce any statute, regulation, ordinance, or policy whereby homosexual, lesbian, or bisexual orientation, conduct, or practices, or relationships shall constitute or otherwise be the basis of or entitle any person or class of persons to have any claim, any minority status, quota preferences, protected status, or claim of discrimination." A constitutional amendment to prevent the legislature from adopting laws to protect certain classes of citizens is a strange animal, to say the least. But like many states, Colorado has an initiative process through which voters can approve constitutional amendments at the ballot box by an up or down vote. Such amendments are placed on the ballot through a petition process. The petition typically requires signatures from only a small percentage of eligible voters. In Colorado, a number equal to at least 5% of the total number of votes cast for all candidates for the office of Secretary of State at the previous general election. In 1996, in Romer v. Evans, in a 6-3 decision, the court struck down Colorado's Amendment 2 under the 14th Amendment's Equal Protection Clause. Justice Kennedy authored the majority opinion. As mentioned, we'll come back to the Equal Protection Clause when we discuss racial discrimination. But for now, note that discrimination, that is, distinguishing between two or more different entities, is not necessarily unlawful. The first question to ask is the basis for the discrimination. If the basis for the discrimination is not something specially protected under the Constitution, the court will usually apply rational basis scrutiny. For example, not-for-profit corporations do not have to pay corporate income taxes, while for-profit corporations that are not closely held do have to pay corporate income taxes. The law discriminates between not-for-profit and for-profit corporations, and this discrimination would be subject only to rational basis review and would pass easily. If the basis for the discrimination is something that is specially protected under the Constitution, a suspect class such as race, then the law must pass strict scrutiny. For some other classes, including gender and illegitimacy, the court may apply a form of intermediate scrutiny. Curiously, Justice Kennedy never really decided whether sexual orientation is a suspect or protected class and did not overrule Bowers. Instead, it seems that Justice Kennedy formally applied rational basis review, or at least simply evaded the issue. Nevertheless, Justice Kennedy stated that a law declaring that in general it shall be more difficult for one group of citizens than for all others to seek aid from the government is itself a denial of equal protection of the laws in the most literal sense. In a dissent joined by Justices Rehnquist and Thomas, Justice Scalia suggested that Amendment 2 did not suggest a desire to harm homosexuals, but rather reflected a modest attempt by seemingly tolerant Coloradans to preserve traditional sexual mores against the effects of a politically powerful minority to revise those mores through the use of laws. He also noted that the majority's opinion appeared to conflict with Bowers, even though Bowers was not overruled. In 2003, in Lawrence v. Texas, by a 6-3 majority, the court struck down a Texas law that criminalized sexual conduct between persons of the same sex. Writing for a 5-justice majority, Justice Kennedy stated that liberty presumes an autonomy of the self that includes freedom of thought, belief, expression, and certain intimate conduct. The instant case involves liberty of the person in both its spatial and more transcendent dimensions. It was time to overrule Bowers, he said, because of changing understanding regarding same-sex conduct in U.S. society and elsewhere in the world, including in law. He grounded the holding in substantive due process, stating that the right to liberty under the Due Process Clause gives petitioners the right to engage in their conduct without intervention of the government. Justice O'Connor concurred in the judgment, but wrote a separate concurring opinion. She did not join the 5-justice majority in overruling Bowers, but stated that she would apply a more searching form of rational basis review under the Equal Protection Clause instead of deciding the case under substantive due process. Under such an equal protection review, she said, a ban on sodomy generally might pass muster, but singling out homosexual sodomy would fail. Justice Scalia wrote a dissenting opinion joined by Justices Rehnquist and Thomas. He argued that countless judicial decisions and legislative enactments have relied on the ancient proposition that a governing majority's belief that certain sexual behavior is immoral and unacceptable constitutes a rational basis for regulation. He bluntly rejected the notion that the Due Process Clause protects a general liberty interest. There is no right to liberty under the Due Process Clause, he said, though today's opinion repeatedly makes that claim. And citizens may be deprived of liberty so long as procedural due process is observed. In contrast, he argued, substantive due process requires a finding of a fundamental liberty interest, and the state regulation is narrowly tailored to serve a compelling state interest. Here, homosexual sodomy is not a fundamental right, he said, deeply rooted in our nation's history and tradition. In a separate dissent, Justice Thomas echoed Justice Stewart's dissent in Griswold that this was an uncommonly silly law, but said that it was the Texas legislature's prerogative to enact such laws.